I'll try to draw some distinctions between what Judge Connor's new initiative, the Peacemaking Court, is doing and what the traditional court system does. And then feel free to ask me any questions if you'd like. First of all, just a little bit of history and background. The Peacemaking Court is new, and so new that we're actually thinking of changing the name already, because it's not a court, but it is a program within the court. So we're thinking of calling it the Peacemaking Program or something else that is not, that doesn't contain the word court in it. Judge Connors became really interested in the peacemaking process. How many of you are familiar with restorative justice? Yes, lots of you. Okay, so it's a very similar process, and I know there are a couple people here who are even familiar with peacemaking. Peacemaking and restorative justice have very ancient roots, and peacemaking is what the tribal communities and courts are using to address issues that come before them in the community. It's very, very close to restorative justice. I would say the main difference between the peacemaking model and the restorative justice model is that it has a lot more kind of tradition, because tribal communities are fairly cohesive, and it has a little bit more of spirituality and ceremony to it than straightforward restorative justice, but it's in restorative practices, but it's very much the same. Now, we're talking about a state court system, so which is a secular system, so we are adapting some of the principles of peacemaking to the state court system, and this is a pilot project. Obviously, we have such a diverse community, we don't have a close-knit community that all honors the same traditions. We don't inject spirituality and things like that into our processes in the court system. So we're adapting some of the principles of peacemaking, and we are going to be using some tribal peacemakers to do our trainings, and we're trying to make this as close as we can. There's one other state court in the country that we know about that's doing this, which is Red Hook in Brooklyn. They started doing peacemaking a year ago in January, and we are receiving technical assistance from the group that is working very closely with Red Hook, which is Court Innovations in New York. So a lot of my questions to them have been, how do you do this in the state court system? How do you bring these traditions in? And they've been very, very helpful in helping us set up a model. So this first year, a lot of it is going to be learning. This is very unique in courts. Obviously, it's completely unique in Michigan, and the goal is to set up maybe a replicable model that other courts can use. So one difference between traditional court systems and peacemaking systems is that the court model is, our justice model is based on basically retributive justice. And what I mean by that is there's retribution. Someone has done something, someone must pay for it. Pay for it with money, pay for it with time, incarceration, whatever the punishment that's appropriate for that is. Those of you who've taken mediation, we've talked endlessly about winners and losers in the court system. So the peacemaking model is based on reparative justice, meaning not only does someone need to be held accountable for what they did, but they need to understand what happened and how it impacted other people in the community, and they need to work out a way to repair the harm to those people and maybe the wider community that was affected by it. So those of you who know about restorative justice, this is all very familiar, right? So it's really based on taking responsibility, repairing harm, and reintegrating into the community. One of the things that Judge Connors feels very, very strongly about is that when people come into the court system, they walk out with a label. You're either a felon or an ex-felon or a neglectful parent or a deadbeat or whatever the issue is, you're labeled. And it's very, very difficult for people to reintegrate back into the community once they have a label. So one of the things that the tribal court system does that the state court system will never be able to do. But for example, when a juvenile comes before them and the juvenile has gone through the peacemaking process, has repaired the harm, has gone through whatever other programs they need to do to be restored, they are given their file, and their file is burned, because that is no longer who you are. You are now a different person. Get rid of the labels. You're not this person that did this bad thing. You're not this bad person. You are who you are now. Well, that's not going to happen in the state court system. Files being burned is just that, and that's not what's going to happen. But it's based on healing. It's based on healing relationships. So it's done in a circle, just like restorative justice is done. This is different from mediation because mediation is really kind of a one-time intervention to resolve an issue. And the hope of mediation is that relationships are repaired and relationships get better through that process of agreement. But this goes, I think, a little bit deeper and really looks for true healing in relationships. And it also may bring in members of the community. So it may not be just this person and this person. It may be the whole family. It may be other people in the community who were affected by it, so that the harm and the reparation of the harm affected the members of the community, the reparation of the harm goes out to everyone. And everyone decides on what's going to happen to repair that harm. So I've done a little presentation before where you show what, for example, victims and offenders want when something has happened. And then what they actually get in the justice system is quite different. Same thing for schools, actually, traditional methods of punishment. But I think peacemaking and restorative justice comes closer to actually giving victims and offenders what they feel they want and need. Now, obviously, there are some people who are sociopaths and people like that who are not going to be suitable for a program like this. But very often, offenders were thinking something completely different than what the victim and other people perceive them as thinking about. Very often, the victim wants to know, the victim feels like, when I get to court, this is all going to be over. Finally, I'll have closure on this. And then they walk away and realize, I'm still scared going home tonight, because sometime that person's going to get out. Why did they choose me? None of their questions get answered. So what happens in peacemaking is it's an opportunity for all of those things to be talked about and answered and addressed. And so it gives, the goal is that it actually is very reparative and gives victims and offenders more of what they actually need to reduce reoffending, recidivism, labeling, and all those things. One of the tribal communities in Alaska, the Kake, K-A-K-E tribe, has had a program going on for quite a while, a peacemaking program, and they did a study of fulfillment of sentences. So if someone's given the sentence, did they actually do what they were supposed to do or not? And they compared it with the Alaska state court system fulfillment of sentences. And the Kake peacemaking process had a 97.5 fulfillment rate. The Alaska state court system had a 27% fulfillment rate. So that conversation, that learning, that information that goes back and forth between people in a restorative or peacemaking circle is vital to helping a person who is offended understand what it actually means to do what he did and not he or she did, and learn from it. Same thing's true, same thing is true in the schools, the school programs that the DRC does, a very similar model. I think a common response to things is, it's not my fault, it's the other person's fault. A student gets kicked out of school. somebody gets convicted in court, it was somebody else's fault, the teacher didn't like me, the judge didn't like me, it wasn't fair, I didn't have a good attorney, whatever. They never get to really think about deeply what they did and what it meant to another person. So that's what peacemaking's about. Judge Connors comes to this through a very, very strong relationship he's had with tribal courts for a long time. And he's become very, very interested in this process. It's a voluntary process, so unlike mediation under the ADR rule, nobody's ordered to come to this. It is completely voluntary. If they don't want to come, or if they don't resolve issues in the peacemaking process, they go right back to the court. And Judge Connors is going to be using some of the same principles, actually, as he addresses the cases with people. So in this particular project, I know that Judge O'Brien is going to be referring some cases. Judge Kunke is going to be referring some cases from the circuit court level, and then Judge Simpson from the district court level. So there'll be a variety of cases. We're actually working with family cases right now on the 3 that have been referred. So divorce, child custody, probate, trust, estates, cases where there's a lot of conflict in a family, and then juvenile cases, delinquency cases. There's a whole wide range of possibilities on juvenile cases. And then also some misdemeanor cases and assault, battery, retail fraud, things like that may come to us. One other thing I want to say, and then I'll take your question, and that's that the project is contracting with the Dispute Resolution Center. So we will be doing some training, and we'll be working with Belinda. We're going to take a small group of people initially, because we're part of this year, most of this year is really learning and development. So we'll have a limited number of cases, so we don't want to overtrain people that we won't have cases for, but we will take a small group of people, and then hopefully part of our grant is that we'll do another training before the end of the grant to expand the program if it's worth doing. So
thank you so much, and you see why I said we could spend the whole time just on this. So 2 questions, and then we'll move on. So Buffy and Luna are the 2 people.
I was just curious about when you're actually in the court, do the parties still have an attorney, or is it just the court without an attorney? Or
you asked a question I'm not ready to answer,
Oh,
right?
okay.
Most of the peacemaking processes do not have attorneys involved. And we've been working with the Court Innovations Project on this. I, in my background as a mediator, have always wanted to involve attorneys in things. But I can really see a reason when you're talking about family relationships and things like that. The peacemaking theory is that clients hide behind their attorneys. This isn't an adversarial forum. And this really isn't a forum, you know, I haven't seen very many relationships repair themselves from a long discussion on legal issues. It's not a forum to discuss that. So it's really to discuss relationships between the parties and to try to resolve some of the other issues that way through that channel. But I'm struggling with that right now, because I am a believer in not separating attorneys and their clients, but we're working on that.
My question is this a limited amount of time that the peacemaking process will be used, and can it be used in other circuit courts around the area? I mean, could we set cases that we might have in another area other than Washington County?
Well, the goal of this project is to provide a replicable model for other courts to use. The question about our other courts using it, there are a couple other courts using restorative justice, and other things are starting. Wayne Mediation Center is starting a program in Hamtramck with the district court judge there. Judge Thomas in Wayne County is doing adult all of that, and adult all of that cases, by the way, are people about ages 17 to 22, which I still consider youth, but under the law, they're adults, they're young adults. Adult all of that cases, she's starting a program in fact, Mark Fincher, who was here a couple weeks ago from ACLU, has been part of that, trying to get that set up, and I've been in on those meetings as well. So it's starting in little pockets. That's a restorative justice. This one is really, working in collaboration with tribal courts and trying to use as many of the peacemaking tribal court principles as possible too. But yeah, I think it is a growing area. I think Melinda can certainly talk to the fact that there are lots of pockets of things sprouting up in communities and schools and things like that, using restorative type practices. So, did I answer all of your?
Yeah, I just wondered if you had a time limit on how
Yeah.
that.
This grant is for a year, but then the hope is that the state court believes they will have money from the legislature, which is always a question, so they can't say for sure, but they hope that they will have money from the legislature again to give to court projects. And we are also looking at other funding to expand the program as well. So we plan to keep going with it. If it's at all successful, we want to just keep building it. And in a year, it's very hard to tell anything. You certainly can't measure things like recidivism and things like that in a year. So we want to keep building the program and keep growing the program. Thank you.
I'm wondering how big the circles will be. I have some familiarity with the South African Truth and Reconciliation Commission, and I also heard, people talk about the importance of being heard. And in South Africa, of course, it was public. A lot of it was captured on film. And so the money that was awarded to people who suffered atrocities was very limited. But I think the opportunity to be publicly heard was, that's always mentioned as one of the valuable aspects of that exercise. So,
when you're saying how big the circles will be, you mean how many will be included in it from the community?
Right.
And that's going to be on a case-by-case basis. Obviously, in a probate case with family members, it's going to be the family members and not community members who are affected by it. But something that a kid does that affects his school community or affects the neighborhood or something, that could be a much larger group. The public-private thing is that it's public for the people who are in that group, but we still do ask for confidentiality, at least confidentiality as to the facilitators, and it's up to the people in the group to decide how confidential they want to make that.
Will you be able to mandate the attendance of essential family members?
No, it's all voluntary. So,
Same process they've developed in terms of what cases are set for referral, what cases are really optional.
the cases can come from a variety of, I mentioned the judges who have said they want to participate in it, but they can come from the community. There was a gentleman who called up and self-referred himself on a case. Because he read about it in the paper. So, I mean, it can come from attorneys before the case has gone to court. The cases can come from community members. They can come from any place. We will take those cases on a voluntary basis.
So is there a strategy in terms of either marketing the program or informing people that something like that? Because I don't know how many people will know about that option.
Yeah, I mean, there will be more marketing. This has been on NPR. It's been in the legal news and AnnArbor.com. Magistrate isn't here. AnnArbor.com is also going to be running an article on it. So, we are going to work on getting the word out into the community.
One of the things that's hard as a mediator is you sometimes don't settle. You choose to go to court where you know there's some kind of emotion here from both parties involved. Is this the kind of, do you think that this court is one of those settings where that is more comfortable?
are they willing to, certainly in cases where there are true victims and offenders, we want to make sure that the victim's willing to take part in it and that the offender's willing to take responsibility. But in cases where there are family members and other people there, we let them know that this is different. This is different from the court system. This is a situation in which we'll all be sitting in the room in a circle. We'll be talking about things that are personal, the basic ground values of respect and so on and so forth apply. And openness is important, and to really honor what other people have to say and to really speak in a rather deep way about things. So we are letting them know ahead of time what this is about, and if that they don't have to do it. I mean, they can choose to do it or not. So, did I answer that?
Yeah.
I want to follow up on what you just said. In that process, in the court, it's public record, in mediation, it's confidential. What is it going to be?
Yeah, the court does not have any access to the information that takes part. So even though it is a program that is being run through the court, it is no different than mediation in that what is said in that group is confidential as to court by everyone. So if one of the parties goes into the court and says, you said this in the peacemaking circle, the judge would be following the same rules that they do for settlement conferences and mediation, and I don't want to hear it. And that what's said in the circle completely stays in the circle as far as the court's concerned, and the files and the records and everything are kept separate. So what would go to the court, again, would be any kind of agreement, or maybe to the friend of the court in some cases when there's custody arrangements and things like that. But, so it's the written paper that comes out of it.
So it just seems to me that would be a really great marketing. Just to say,
Yeah.
this stuff is going to be public record.
Yes.
It's a little stronger than, we don't want to hear it. It's, we can't. There's a prohibition on that. So, because the concept is that you want people to go and talk candidly and settle. And so sometimes they will reveal things that they would, they lay their cards on the table, which they're not gonna do when they're in a high stakes in the courtroom kind of scenario. So, they still get to play those cards in the courtroom if they need to. So that's why it's like, no, you cannot reveal to us what was said in settlement or in peacekeeping in any of these other arenas. Like you say, it's not because we're like, we don't want to hear it. It's, we can't, because otherwise it undermines the whole process of openness in discussion. Yeah.
And we're actually, this is a good question to throw out to all of you. We're looking for a place that is actually, right now we're using the jury room in the court. But we're looking for a place, at least for many cases, where security isn't an issue and so on and so forth, where we can go away from the court. We just haven't found the right setting yet. So I want the ideal setting with a fireplace. And we don't have a budget that would rent a place. That's the other issue. So for now, we're using the jury room, and we're going to be setting it up in a very different way than the jury room is usually set up with the circle and maybe some other things in there. So.
One place that's really great is by botanical gardens.
Pardon?
By botanical gardens, if you have a large group and you want to have a nature setting and be outside.
That would be great.
They do rent.
I would rent.
They do rent space.
Well, they give it away. And who is it?
Botanical garden.
Botanical garden.
Oh, yeah, so would they let us use it? I don't know. I mean, that's a great, I will ask. That's a great suggestion.